You think you have a great case, but you can't understand why the defense doesn't want to settle your case. Would you like to learn what this is about? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. You suffered significant harm because of somebody else's carelessness. And now, as a result of that harm, you now have some disability that's going to affect you for the rest of your life. And you believe you have a very strong case. You believe that there's no doubt in your mind that the other person caused your harm, that they were responsible for your injuries, and now you can't understand why the defense and their attorney do not want to go ahead and settle your case, certainly not at the beginning of the case, certainly not in the middle of the case. And as you're getting closer to trial, you cannot understand why they're not making an offer to settle your case. Doesn't make sense. Well, let me share something with you. Most of the time, there is no real incentive for the defense attorney, to try and settle your case early. Do you know why? Because they gain no benefit, no real inherent benefit to settle your case early, except in one instance. If it's clear cut that they did something wrong, and there's no doubt about it, the question will then pivot to, well, what are your injuries worth? And that is always, always a hotly contested issue. So it's never clear cut, even if you have significant injuries, and even if those injuries are lifelong and are going to affect you forever. The real question is, what is the true value of your injuries? Now, from the defense perspective, they have no incentive whatsoever to settle your case early. The only real incentive that they would have to settle your case early is if they get some sort of discount as a result of trying to settle the case early on. That's the only benefit that they can have. Otherwise, they are going to try and hold on to their money for as long as possible. Why? Because again, there's no incentive, there's no reason for them to try and get rid of this case earlier, because they know at some point they're going to have to try and negotiate or settle the case if it's so clear cut that what happened to you was because of their client's wrongdoing. So ultimately, it may wind up that you have to go to trial, and a jury will have to put a number of value on the extent of your injuries. When you learn that the defense is not willing to negotiate and they're not willing to settle your case, don't take it to heart and think that it's punishing you. The reality is that there's no great incentive for them to go forward, try and settle this case, unless it is so clear-cut and everybody agrees on the extent of the damages, which will very, very rarely happen. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into the mindset of the defense as you proceed through the litigation process. And that could involve a medical malpractice case, an accident case, or even a wrongful death case here in New York. You know, you're probably watching this because you do have questions about your own matter. And if you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.